nitty-gritty of, so how did we get Donovan's citizenship? So as he mentioned, he got this rejection, saying you submitted these documents, but it's not enough. So the first place, the opening we had was section 5.4, cases of special and unusual hardship. And hardship was not the problem in Donovan's case to prove. Because of his health situation, I felt I could, in my submissions to the government, I could argue without any hint of exaggeration that a grant of citizenship for Donovan McLaughlin was a matter of life or death. I had a letter from his doctor saying that if he was not able to access badly needed medical care in Canada, that it was not a matter of if, but when he would have another heart attack, and that heart attack was likely to be fatal because of the weak condition of his heart, because of previous heart attacks. Hardship was not also difficult in Donovan's case to argue because he has 3 young Canadian citizen children. And I presented arguments for best interests of a child, which the government has an obligation to consider in applications directly affecting children. Citizenship legislation doesn't specifically lay out an analysis for best interest of the child, but we do have direction from the Supreme Court of Canada in the Baker decision. And we also have direction in the operational manual for humanitarian and compassionate grounds application, which lays out in quite detailed steps a best interest of the child analysis. So hardship was not the problem. Proving that Donovan was who he said he was with no documents, that was the problem. How does someone exist for 61 years without documents? And so this was the problem. So I started thinking, what are the things that anchor someone to society? There are things like schooling records, immunization records, visits to a doctor, visits to a dentist, lease agreements with landlords for renting, electricity bill, all these things. But in Donovan's case, precisely because his statelessness forced him into the margins of society and he wasn't able to work legally, he had a very unconventional, off-the-grid, transient life. So he has no formal proof of employment contract. He's not allowed to work legally. Much of his life he was homeless or camping basically, or in substandard housing with the kind of landlords who don't do paperwork. So we didn't have these documents. But what we did have, we had his spouse, who could write an affidavit about they were together since 2005. We had members of the Selkirk First Nations community in the Yukon who provided affidavits that they knew him, that they knew him to have consistently lived in Canada. We were able to go back, I believe, to about the mid-90s. We also had to prove that we had exhausted all reasonable efforts to establish his identity. So Jackie Scott of the Last Canadians did hour upon hour of genealogical records trying to find any relative of Donovan McLaughlin. And as you can imagine, with a name like McLaughlin, it's a needle in a haystack. And we weren't able to find anyone who we could say most probably was a relative of Donovan's and then possibly witnessed his birth, et cetera, but at least we could convince the government that all reasonable efforts were exhausted. The other thing we had to do, Section 5.4 is really only supposed to be used in exceptional circumstances, and you have to show that there is no other remedy, that you need the minister to step in and intervene because there is no other remedy. So with an articled student, we scoured through the vital statistics legislation of every state and province where Donovan might have been born to show that it was not an option for him to get a delayed registration of birth certificate. And thankfully, to the government's credit, after everything was submitted and all this support, he was granted citizenship, and it was granted relatively quickly. And they did heed our request that because of his health situation, he needed urgent processing. But as you can see when I talk about Donovan's case here, it's not easy. And how is someone who's not, it was hard for me as a lawyer, how is someone who's not legally trained who isn't allowed to work, so probably can't afford a lawyer, how is someone supposed to go through all these steps? It's not fair. A colleague in BC, Shannon Salter, describes process as like a bouncer at a nightclub, decides who gets in, who stays out, and what's the paperwork that's required, and it really is like that. With Kia, it's a little bit different. So as he mentioned, Kia's Member of Parliament office, they filed a humanitarian and compassionate grants application. And the reason that route was taken versus a direct citizenship application is because Kia, unlike Donovan, doesn't have a Canadian parent. He was born in Tucson, Arizona, to an American mother. So we've had sort of a dual strategies, and we're still in this dual strategy because we don't have a decision on Kia's case. So we have a pending humanitarian and compassionate grounds application. The government has accepted the first stage of that application, which is that they agree there is sufficient humanitarian and compassionate grounds application to allow him to have this application from inside Canada. They have also shown compassion in finally waiving the requirement for an identity document, because that's where we were stuck for a long time. That's the second stage of the processing, is criminal clearances, identity document, and a medical test. So basically we made the argument that we don't have a birth certificate, but we have a DNA test to an American mother. We've proved she's her mother. We've proved she's American. That should be enough for the Canadian government. The fact that whether or not Kia was born in Arizona or Indiana it matters to Arizona, vital statistics, in issuing a birth certificate, but it shouldn't matter to Canada. And Canada has accepted that, and we're thankful for that exercise of compassion. So we're waiting on the final determination of permanent residency, but at the same time, I've submitted a Section 5.4 application asking for citizenship, because the PR application doesn't solve Kia's statelessness. He's still stateless, and there's the absurdity too. He's lived here since he was 2 years old, so he gets his permanent residency. He's going to have to live for another 4 years as a permanent resident to satisfy the residency requirement, have another year of processing time for his citizenship application, wait another 5 years before he's a citizen. So arguing, given that the particular circumstances in his case, the government should expedite that and hopefully grant him citizenship. Just very briefly in conclusion, because I think I'm running out of time. In terms of recommendations, I echo what's been said. There needs to be a simplified administrative process that's clear for stateless people. I agree with Andrew that right now it's a state of denial. It's working in this cloud. There needs to be a more defined process. Section 5.4 is great. I'm glad it exists. But it's the minister's discretion. Something so important to someone's fundamental human rights should not be left to discretion. It's great when that discretion works in their favor, but it's a risk, and there's no accountability. And accountability is one of the cornerstones of a properly functioning legal system. And we don't, 5.4, a discretionary section for this is not enough. We need more than that. The other thing, so we need a more defined and simplified process. I think we also need cooperation from provincial governments who administer legal aid systems to have mechanisms by which stateless people can access legal aid. I don't know how you go through this process without legal counsel. It must be extremely, extremely frustrating, and for a lot of people, futile. So I think there's a fundamental access to justice issue here that the provincial government can go far in addressing. We need a new Citizenship Act that's comprehensible, so we know what a Canadian is. And in terms of positive signs, though, I will say that the government, I have seen them behave in a much more collaborative, problem-solving way than ever before. When I heard Justin Trudeau's victory speech about sunny ways, I didn't really know what that meant, but I found recently in speaking with officials at IRCC that I've been given unprecedented access, and that my conversations with them have been constructive in a way I've never seen before. Key people high up in the case management branch have been calling me, emailing me, responding to my requests. they have been providing me guidance because I'm relatively green at this. I submitted the 5.4 for Kia. I didn't know I should also submit a 5.1 application, and I told them, which is the usual citizenship application for an adult, I submitted it. I didn't really think we needed that because I can't fill out most of the questions. He doesn't fit. He doesn't have the documents required in that. But so they provided us with guidance, and that has been really helpful. So I do see a change, and I think that's part of what Donovan's talking about. The key thing here is compassion. We need a rights-based approach to these situations. Otherwise, the law is just going to be this blunt instrument that's not serving the principles of justice and the things that we all care about as Canadians. When we hear about Dupan's case, Donovan's, Kia's case, I'm sure all of you are like, that's horrible, that's absurd. Like, the everyday Canadian on the street understands this injustice, and it's the government's responsibility to address it. Thank you.
Just a brief comment. I'm convinced that the Income Tax Act does not provide for statelessness. Okay, here I am on behalf of clients whose case is now presented before the federal court and has also filed an application under 5.4 of the Citizenship Act. I'm representing children, 6 minor children, aged 8 to 18, that were Canadian at one point, and they were deprived. Their citizenship certificates were canceled. And Andrew, this is something you need to add to your you said 2 ways to lose one's citizenship. There's a third way. They can cancel the citizenship certificate issued. And this is what happened here. So here's the background of this situation. All 6 children involved in this deplorable situation are bright and exemplary. Their age varies from 8 to 18. Their upbringing prepared them to be model Canadian citizens, despite their ideals, dreams, and intentions, and to no fault of their own, their entire future is highly compromised. All 6 children were abandoned at birth in Egypt and are unofficially adopted. And I stress that part, unofficially adopted, because Egyptian laws does not allow for adoption. What it allows is kafala under Muslim law, which is the equivalent of a tutorship, not of an adoption. So, parents, what I will refer to parents, but they're not parents because they were not the adoptive parents. They're not allowed to. Anyway, in order to bring the children to Canada, their parents declared them as being their biological children. The standard way to proceed was for Christian Egyptian mothers to give birth in a convent, orphanage, and leave the child behind. Adults would come around and, with the help of well-intended convent and orphanage personnel, a birth certificate would be issued in the name of the child, naming both parents as Canadian. Of course, the child would then be a Canadian, born outside the country to Canadian parents. But does not apply only to Canadian in this particular case. This is the way it's done in Egypt, period. Any Christian born out of wedlock in Egypt is abandoned in a convent or not, who is abandoned or in a convent or orphanage is treated the same way. People come around and register them as their children, regardless of the real biological link. So, birth certificates that were issued in the name of these children were afterwards presented to the Canadian Embassy in Cairo by the so-called parents for the issuance of Canadian official documents, citizenship documents, and ultimately passports later on. The Citizenship Act provides that a child born out of Canada to Canadian parent is entitled to Canadian citizenship. They were given a Canadian certificate, citizenship certificate. But years after these facts, all 6 adults, because we're talking about here 3 families of 6 adults, were charged under Section 57.2 of the Criminal Code for false representation in obtaining a passport and for false representation under Section 127A of the Immigration and Refugee Protection Act for false representation. So these 3 adults, 1 in each family, pleaded guilty to the above charges. The 3 others were charges were withdrawn, noli prosequi. The Honorable Justice of the Quebec Court, who was asked to decide on the applicable sentence, granted, despite what I have said, an unconditional discharge to all parents. Nothing has happened for them. In doing so, he confirmed that there had never been any form of commercial transaction or any exchange of money in these processes or else. This was done out of good faith for the sole purpose of avoiding the children that if they had been left in the orphanage, they would have gone to the street some years later. In weighing the variable facts that led to his conclusion, the Honorable Justice took into consideration the following factors. On the negative side, yes, the aggravating factors that they did not comply with the passport issuance process, of course. They had some planning, of course, they had to think in advance to do what they did. And they also disrespected the international adoption process because it's not an adoption. But then on the positive side, the attenuating circumstances, he said, well, they've entered a guilty plea, despite the fact that the RCMP did not conduct any investigation with the Egyptian authorities. Legal and psychological evaluations were very favorable to the accused. And of course, you can understand that there's been a lot of problem on that side. The overall impact of the legal process they had been subjected to, and this happened some 3 years after the actual charge being laid. They all recognized their responsibility for the charge. They did show a lot of remorse. They had no criminal history. And they had a firm intention to make a substantial donation to a charitable organization as a consequence of all that. As a matter of fact, they did pay $5,000 per child to a charitable organization. The devastating consequences imposed on their privileges as adults, they've lost their passport, were revoked because they made a false declaration for the purpose of obtaining passports for others, as well as those of their children. The judge did mention the fact that there would be some citizenship issues at stake, and the administrative difficulties paired with the excessive sanctions compared to the act committed. So we weighed all these factors and discharged completely, unconditionally. Despite that, the compassion and comprehension of the Honorable Justice of the Quebec Court did not put an end to the children's suffering. The anticipated consequences on the children outlined in the sentencing judgment did materialize. During the criminal proceedings, a firm commitment, thank God, was taken by the Crown's attorney not to deport the children back to Egypt. Each parent was then notified by CIC, name has changed, of the intention to recall the citizenship certificate of the children that were issued upon their entry in Canada or when they were about to enter Canada. And CIC, generously, was inviting the parents to prepare submission for residency application based on humanitarian compassion ground for each child, once the citizenship certificates would be recalled. And while waiting for a new residency status to be granted to them, they said, we'll grant them a temporary resident status, temporary resident permit. That's fine. Today, how do I see the thing? It is totally impossible for any of the children to obtain certain official documents, as you can imagine. Forget about the birth certificate, same for the passport from Egypt. That would confirm their birth, their identity, which would be requested at all stages of the proposed immigration process by CIC. Michelle was lucky enough to get a waiver of the identity document, but I just can't say that I'm going to get that point. The other issue I have in front of me is also the parentage, the lineage. I have no ways of going back to the parents. I have no ways of obtaining proof of their birth. I have no ways of obtaining, for the purpose of the immigration process, be it sponsorship or anything else, I have no ways of getting a declaration of adoption by the parents. They don't know who they are. They don't know where they are. It's impossible. So after the rendering of the sentence and the exhaustion of the right of appeal of the order, We submitted detailed agency consideration to case management, CIC case management, along with the psychological report on the consequences of these children to be deprived of the only citizenship known to them, and consequently made stateless by their mother country, urging, therefore, CIC not to revoke the citizenship status of the children. But if they were to do so, it had to be done urgently so as not to lose the recourse they had at that time before the Governing Council, which was abolished by the New Citizenship Act. Having received no reply whatsoever to the official letters that we did send, and because of the coming into force of this new citizenship law, we initiated mandamus proceedings before the federal court to force the rendering of a decision. Finally, in June of 2015, during the federal court proceeding in mandamus, we've learned from the opposing counsel that the children's citizenship certificate had not only been recalled, but they had been cancelled, rendering the children stateless. The mandamus proceedings were, of course, finalized. We had obtained what we wanted. The fact on which the recall was based were known to us, but we were aiming at this special recourse on agency grounds before the Governing Council that existed. At the time, revocation involved an ultimate recourse before the Governing Council, that is the cabinet. But due to soon to materialize legislative changes pursuant to the adoption of these changes to the Canadian Citizenship Act, the decision of revocation would soon be the sole responsibility of the minister and no longer with the Governing Council. We believe that as Mr. Wodinsky and Ketriuk were successful in their appeal of their citizenship revocation before the Governing Council, so would be or could be 6 innocent minor children. Now, who are these fellows? You know them. Maybe I could provide you with a few notes from Justice Stratus from the Federal Court of Appeal. Here it is. Shortly after the end of World War II, the respondent, Wodinsky and Ketriuk, immigrated from war-ravaged Europe. They adopted Canada as their home country. They became citizens. They have lived in Canada ever since, for over half a century. However, each had a hidden past. Only recently has that past come to light. During World War II, each served forces or in association with forces that committed brutal, inhumane crimes. Each concealed that past from Canada's immigration and citizenship authorities. Under subsection 10 of the Citizenship Act, citizenship can be revoked where it was obtained by false representation or fraud or by knowingly concealing material circumstances. Citizenship revocation proceedings under subsection 10 of the Act began, again, Mr. Wodinsky and Ketriuk. After an exhaustive fact-finding process described later, the Minister of Citizenship and Immigration issued reports recommending that the citizenship of Ketriuk and Wodinsky be revoked. But the Governor in Council decided to reject the Minister's recommendation. As a result, Mr. Wodinsky and Ketriuk today remain citizens of Canada. So these are the fellows that made it to the Governing Council. We, with minors, just can't make it. For these children, the cancellation decision were based on the fact patterns identified earlier, whereby they would have obtained citizenship by false representation from third parties, the adults. All 6 decisions were challenged before the federal court. Leave authorization were granted, and a common hearing is set for early April. The purpose of these legal proceedings is to set aside the decision taken because the minister failed to take into consideration the humanitarian and compassionate grounds we submitted, delayed intentionally the rendering of the recall and cancellation decision so as to prevent the children from submitting their cases to the Governing Council, and as a consequence of these decisions, so take it, children are now stateless. There is, however, no guarantee whatsoever that the federal court will decide in favor of the children. If it does, their status will be in limbo during the re-evaluation process, and as their case will have to be reassessed by the current administration. But as a safety net, not knowing what would be the outcome of the federal court, and despite what we had done there, we submitted last August an agency application under 5.4 of the Citizenship Act for the issuance of new citizenship certificate for the children. because it is within the discretionary powers of the minister, as was Michelle mentioning, to grant the citizenship in favor of the children. These applications for Canadian citizenship to the minister focus on the best interests of the children, to alleviate their special and unusual hardship situation, and to take into account the consequences of statelessness on their development. Basically, it's argued that the children have no knowledge of any other country but Canada. They've always identified themselves as Canadians since coming to Canada within a few days following their birth. They were born in Egypt, but have lived all their entire life in Canada. They do not speak the language of that country of birth, but the language of this one, French and English. They are innocent victims of the behavior of adults which were sanctioned in discharge. Children should not suffer from these actions, especially not being made stateless, as they now are, due to the decision of CIC to render them stateless, forcing them to face a lengthy process to reacquire their identity as Canadian citizens. These exemplary children should not be submitted to such an ordeal and be sentenced administratively for what adults have done on their behalf. The children should not be victims. They have no reasons to continue to suffer, to be hostage of administrative decision, of administrative delays or bureaucracy, and to be put in an administrative limbo for a minimum of 7 years. It serves absolutely no purpose whatsoever. Because the Egyptian law does not recognize the just solely rules under to acquire citizenship. It recognizes only the just sanguine, provided we have father and a mother. But we just can't identify the mother or the father from Egyptian origin. So there we go. It's impossible to get there. So if we were to ask or to be requested biological evidence, DNA or anyone, we just can't go further. There's no way we can link them to any parents in Egypt. And you can think that the official documents that were used initially to obtain the certificate in the first place are no longer usable, to say the least, to avoid any further consequences. If there is no outcome from the processes above, the children will have to become permanent residents again prior to becoming Canadian citizens, a process which in itself will take at least 3 years by today's processing standard on agency application, and I'm very conservative on the 3 years here. However, we expect this period to be by far longer, as some significant difficulties are foreseeable in establishing their identity at birth, their lineage, their parental rights, and the adults having taken care of them since their birth. In the meantime, they are considered as foreigners under the URPA. In the only country they have known since their birth, they will need to wait another 4 years after becoming permanent resident before applying for citizenship. Now, there's a bit of a distinction between a minor and an adult, but understand that by the time they reach the point to become permanent resident, time will have gone by, and the 8-year-old will likely be 13, 14, and soon to be an adult, if everything goes accordingly. So once they become permanent resident, their status would improve. They would be issued a permanent residency card. That would be fine. However, they just can't travel because they need a passport that comes along with the permanent residency card in order to go out. They just can't go to attend any form of trips, school, or whatever you can think of that would happen to any child or a teenager of that age. How often have we not gone to New York to see the United Nations, how it worked? This is part of the curriculum of all schools. They just can't do it. They're going to have to lie about the situation they're in if they are even able to attend school, because this is an issue as well. Yes, it's mentioned that it's possible to attend school without a work study permit. Yes, it is, indeed. But don't forget, we're in Quebec. In Quebec, you need a CAQ. And to get a CAQ, I have to prove that I have the means to go to school. I have to prove that I have the means to pay the tuition fees. Now, what are the tuition fees for someone in the primary level? $5,000 per year. Secondary level, $6,000. College, $8,000 a year child. And university, it's at least $10,000. So, and these are only some of the issues that can be raised. So these Yesterday, were all members of the large Canadian family, and now they no longer are. They have been rejected by the only country they have ever known, rejected to last years to come. We are talking here about children who will, in every case, have to come to terms with the fact that they were abandoned at birth.